Breaking news. Welcome to today's headlines. Biafra agitations. Hip-hop leader. Kanu sues Chief Judge of Federal High Court. Chief Registrar for bearing journalist. Public from terrorism trials. Biafra agitations. Hip-hop leader. Kanu sues Chief of Judge of Federal High Court, Chief Registrar for bearing journalist, public from terrorism trials. To my dear listeners from wherever you're listening from, please stay tuned as I read today's news. Leader of the indigenous people of Biafra, Nnamdi Kanu, has sued the Chief Judge of the Federal High Court of Nigeria, Honorable Justice John Itoho, and the Chief Registrar of the Federal High Court of Nigeria over the new practice directions on the hearing of terrorism cases. Some weeks ago, Justice Itoho issued practice directions on trial of terrorism cases, noting that the distance and size of perimeters to be secured for the trial shall be determined based on the recommendation of security agencies on a case-by-case basis. It means terrorism trials, including the ongoing trial of Nnamdi Kanu, and other related ones will be done secretly, even without journalists, except the judge rules otherwise. Kanu's trials by the Nigerian government, which continued on April 8, was the first casualty of the new directive. In an originating summon with suit number FHC ABJ CS 550-2022, which was filed on Monday, April 25, Kanu's lawyer, Ifeanyi Ejiofor, sought answers to whether the powers conferred on the first defendant includes the power to make directions for regulating trials of terrorism offenses in the Federal High Court, considering the provisions of Sections 36, 1 and 364A and B of the 1999 Constitution of the Federal Republic of Nigeria as amended. Ejiofor argued that the said practice directions were issued without the approval of the Federal Executive Council, formerly the National Council of Ministers of the Federal Government of Nigeria. The lawyer said the IPOB leader was not afforded any hearing before the said directions were made by Justice Itoho. He further argued that his client, Kanu, against whose interest the said directions were primarily made, has already been publicly tried and condemned by the federal government of Nigeria and our Attorney General. That I know as a fact that it is in the interest of justice and fair hearing that the plaintiff, who has been so tried and condemned publicly by his accusers, enjoys a public trial, devoid of the restrictions contained in the practice directions, he added. He also noted that the practice directions apply to and affect the proceedings in charge number FHC AB CR 383-2015 pending before Honorable Justice Binta Onyako of Court Number 2, Federal High Court, Abuja, in which the plaintiff is being prosecuted under the Terrorism Prevention Amendment Act. Ejiofor further urged the court to restrain the defendant and their agents from applying and enforcing the provisions of the Federal High Court Practice Direction on Trial of Terrorism Cases 2022. Other reliefs sought include a declaration that the provisions of order of the Federal High Court Practice Direction on Trial of Terrorism Cases 2022 are already the subject of Section 36, 4A and B of the Constitution of the Federal Republic of Nigeria, 1999 as amended. And consequently, they are odious, inoperative, and outrightly ultra vires. The first defendant, invalid, null, void, and of no effect whatsoever. A declaration that the failure of the first defendant to first seek and obtain the approval of the Federal Executive Council or the National Council of Ministers of the Federal Republic of Nigeria prior to enacting the Federal High Court Practices Direction on Trials of Terrorism Cases 2022 as required by Section 44 of the Federal High Court Act renders the Federal High Court Practice Direction on Trial of Terrorism Cases 2022 ultra vires null and void. A declaration that Order 3, Rules 3B and D of the Federal High Court Practice Direction on Trials of Terrorism Cases 2022, which respectively empower a Federal High Court trying terrorism cases to receive evidence by video link and to receive written disposition of expert witness, are inconsistent with items 23 and 68 of the exclusive legislative list, as well as paragraph 2b of part 3 of the second schedule to the Constitution, which confers on the National Assembly the exclusive power to make rules of evidence, both substantive and adjectival, and are therefore ultra vires null and void to the extent of the inconsistency. To my dear listeners, from wherever you're listening from, please stay tuned and please do drop by at the comment section and let's know what you